Hi, I'm Tony Munter of Benowitz, and I want to talk about materiality in False Claims Act cases. If you've been studying the False Claims Act at all lately, you've been confronted with this concept. The Supreme Court upheld the relator's position in what we call the Escobar case and upheld the idea of implied certification in favor of the relators in that case. Yet the defense bar has reached for that decision in order to try and justify the idea that materiality is some new provision in the law that we have to address. Well, there's nothing really new about this. We've always had to show how the fraud in a False Claims Act case was material to the government's decision to pay. We've always had to demonstrate that the government, in fact, would not have paid but for the defendant's fraud. Some laws are helpful to us in this regard. There's always the necessity to show that a medical procedure was really required. That's called medical necessity. If you don't have that, then you're violating the law and you can't charge the government for a Medicare service. Similarly, the anti-kickback statute can be very helpful. Government contracting is complicated by the idea of materiality, showing that for certain that a government program would not have paid is not always easy. But it's not a new issue. This has always been a problem. We've always had to address it. We've always had to be able to show that the government really was harmed by the defendant's fraud.